Hey everyone, it's Rob Ryder. Been a little while. I had some kind of viral infection that really messed my head up and my chest. Spent a couple weeks in bed and last 2 weeks trying to recover. Much better, thank you very much, and thanks for all those who wrote asking where I was. But I was sick in bed. Kind of back at it now, and everything must be for a reason. Had a chance to not think about law or anything to do with law for a couple of weeks, and get back into it and trying to get your head back into what you were thinking about before. And well, here we are today, and a couple things that have happened is this will be in another video. First, I thought I better do a video on where some of this comes from that we're trying, but we're trying the church courts, the Apostolic Signatura, which was in the last video I did. If you were to search by upload date, very last video, talking about the Apostolic Signatura. And we've actually, by taking our petitions to the Chancellor at the diocese, in one case now it's going to the Apostolic Signatura over in Rome. In another case they said they weren't going to handle it because it's a personal matter, but when you read the definition, well, that's what it's for. It's for private rights, to guard your private rights. And so we're going to have to write a letter to this Chancellor and explain why we can do this. But at the end of the day, anything that has an oath, notary seal, a promise, things like that, they're all concurrent. The church has concurrent jurisdiction, and the sovereign pontiff has jurisdiction over all baptized people. So I don't care if it's a judge or an attorney or whoever it is. That's not the person. It's not the position I'm going to the church with. It's another baptized Christian who wasn't acting like one. And so you don't even need to be a Christian to use this court, right? If the way the Catholic Church looks at it, right, if all men are created equal, so you can't lie, cheat, and steal from anybody. And we're supposed to be using this court. Now the problem is the church, most people in the church don't even know they can do this, and that's what this Chancellor has told us, that you guys are teaching me. I didn't even know we could do this. Right? It's not things that are talked about, and so what you need to do, or what we're going to be doing if we really have to use this court, is making the church aware that it is a church matter, because it's a matter of faith and sin. It may have to do with my foreclosure, but some of the other side is committing perjury. That's in your wheelhouse, church. You have a frickin' canon on perjury. So by canon law, they have jurisdiction. Just by definition, they have jurisdiction. But how do things get to be so crazy in the first place? And that's kind of what this video is about. Because there still may be things we can do for those that have a problem, that really think the Catholic Church is the problem. Well, there's still other options we can try. But going to have to kind of bear with me, because there's a lot of reading to do on this one, to explain the difference between the adversarial, which is common law, versus inquisitorial, which is civil law, two different systems that are used in court. And how in America the use of administrative law, which uses the inquisitorial system, has created a shadow government by circumventing the separation of powers. When you look at an administrative organization within the government, they have rule-making power, adjudication power, and enforcement power. Rule-making is legislative, adjudicative is judicial, enforcement is executive. All three powers of a government are within these administrative departments. That's how they circumvented separation of power. Now they all answer to the executive, so actually the executive is acting like a king instead of like a president or a governor, because they have all three powers through this particular organization that answers to them. That's the way they set it up. So I'm Rob Ryder. It's 10/26/2013. My email address is courtofrecord@AOL.com. Phone number 616-712-6179. And if you can help keep the lights on, it's that time. I got to pay rent at the end of the month, and I don't have enough. Can't pay rent, can't buy groceries, can't pay the cable, can't pay the electric. If you can help, I'd really appreciate it. The PayPal account name is, and this is actually the name, it's my daughter's name, ashleyrytlewski@gmail.com. Snail mail, if you were going to send a money order or check. Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. Okay, so you may want to pause this for a minute, go grab a cup of coffee or something, because I got a lot of reading to do, and I'm going to try to go slow and go through it step by step. But it will be good to help explain why things are the way they are, and not as they appear to be. Because you're never really in a judicial court. You're only in an administrative court. Now, there is something we can do about that, it looks like, and we're going to get to that. But first, the basics. So here we go. Here we go. And this would be out of Wikipedia, talking about an inquisitorial system. It's a legal system where a court or part of the court is actively involved in investigating the facts of the case, as opposed to an adversarial system where the role of the court is primarily that of an impartial referee between the prosecution and the defense. Right? So if the judge is up there actively investigating the facts of the case, well, it's an inquisitorial system, as opposed to an adversarial system where the both sides are presenting their information, and the judge is just acting as a referee. I would say in a foreclosure, you could say it's an inquisitorial system. The judge is the one asking you questions. Traffic case, inquisitorial system. But it goes deeper than that. So these systems are used in some countries with civil legal systems as opposed to common law systems. Also, countries using common law, including the United States, may use an inquisitorial system for summary hearings in the case of misdemeanors such as traffic violations. Well, when you think about it, they may call it civil procedures and criminal procedures, but the only reason you're in court is somebody saying that you broke the law. Right? Either you haven't done what you've said you would do in a contract. So there's two kinds. There's private, between you and somebody else, and there's public, between the state and you. Either way, they're saying you broke a law. So it's at least a misdemeanor. But in this case, we're talking about such as minor traffic violations. And when you think about it, if you've ever had a minor traffic violation, you're dealing mainly with the prosecutor. And the prosecutor is the one who is getting a guilty or not guilty plea out of you. As you'll see, the prosecutor is acting as the judge in this case. And because the procedure isn't written down and we're not actually admitting to the fact they're using this inquisitorial system, it's all done by custom, it looks like you're pretty much screwed unless you complain to the proper authorities. And we're going to get into who that might be. Excuse me, I'm going to probably cough a lot during this. I still have that problem. And now the phone's going to start ringing. In fact, the distinction between the adversarial and inquisitorial system is theoretically unrelated to the distinction between civil, legal, and common law systems. So apparently it doesn't matter if you're civil or common law. If you want to use the inquisitorial system, theoretically they found a way to do it. Some legal scholars consider inquisitorial misleading and prefer the word non-adversarial. Now, in a foreclosure, the defendant is an account. It's your all capital letter name, and somebody's claiming the account. because the what do they call them? Did a video on this just before the one on the Apostolic Signature. Has to do with the stakeholders. A stakeholder is supposed to be an uninterested third party who's just holding the stake, right? Holding the stuff, like the escrow account. All right, and so the cases are considered non-adversarial because you're really just trying to determine whose property it is. You're not really saying that they've taken it from you. It's just, hey, judge, as the stakeholder, I don't want to determine whose property it is. I want you to do it. That's what a stakeholder does. But they're considered non-adversarial, right? As opposed to adversarial, where the prosecutor is your adversary, or the plaintiff is your adversary, and right, you're the defendant. Non-adversarial, there isn't an adversary. The function is often vested in the public procurator, as in Russia, China, Japan, Scotland. The inquisitorial system applies to questions of criminal procedure as opposed to questions of substantive law. That is, it determines how criminal inquiries and trials are conducted, not the kind of crimes which can be prosecuted. It is most readily used in some civil legal systems. However, jurists do not recognize this dichotomy and see the procedure and substantive law legal relationship as being interconnected and part of a theory of justice as applies differently in various legal cultures. In some jurisdictions, the trial judge may participate in the fact-finding inquiry by questioning witnesses, even in adversarial proceedings. The rule of admissibility of evidence may allow the judge to act more like an inquisitor than an arbitrator of justice. Right? So, they've tweaked things where they can say that we have this common law system, but they're actually using civil law procedures. Until the development of the medieval Inquisition in the 12th century, the legal system used in medieval Europe generally relied on the adversarial system, common law, to determine whether someone should be tried and whether that person is guilty or innocent. Under this system, unless people were caught in the act of committing the crimes, they could not be tried until there had been formally accused by their victims. The voluntary accusations of a sufficient number of witnesses, or by an inquest, which was an early form of grand jury, convened specifically for that purpose. Right? An inquest would be for one particular case, not a grand jury just sitting there looking at numerous different cases. A weakness in this system, right, which is the accusatorial system, was that because it relied on the voluntary accusation of witnesses and because the penalties for making a false accusation were severe, victims and would-be witnesses could be hesitant to actually make their accusations to the court for fear of implicating themselves. For fear of, what's the Fifth Amendment? Right? Bearing witness against yourself. Because of the difficulties in deciding cases, procedures such as ordeal or combat were accepted. So because nobody would step forward and basically bear false witness, right? If you're saying, hey, this is mine and the other guy's got it, I want it back, and you couldn't get any witnesses, and false accusation would be incorrect to do, well, you could get around that by ordeal or combat. Beginning in 1198, one of the popes issued a series of decretals that reformed the ecclesiastic court system. Under the new process, inquisitorial procedure, an ecclesiastic magistrate no longer required a formal accusation to summon and try a defendant. So, you needed a formal accusation in the past. You needed to have a written complaint, apparently. Instead, an inquisitorial court could summon the interrogate witnesses of its own initiative, and if the possibly secret testimony of those witnesses accused a person of a crime, the person can then be summoned and tried. The inquisitorial system was first developed by the Catholic Church during the medieval period. The ecclesiastic courts in the 13th century England adopted a method of adjudication by requiring witnesses and defendants to take an inquisitorial oath administered by a judge, who then questioned the witnesses. In an inquisitorial oath, the witness swore to truthfully answer all questions asked of him or her. Well, that's how it should be done if you're using the inquisitorial system. However, in America, Fifth Amendment, that you don't have to, what's the words? I can't remember the exact words, but whatever the Fifth Amendment is, right? So they said, well, you have the right not to take an oath. As a defendant in a case, you want to take an oath, and you want to say, I don't know, the plaintiff anything, because the plaintiff doesn't frickin' exist. It's not the bank. It had nothing to do with your account ever. It's a made-up name. Just take the name of the plaintiff and go try to find a certificate of existence or a DBA or whatever. It doesn't exist. They don't exist. And they got away from, so because we're not using the actual inquisitorial system here in America, it's quasi-judicial, they're not making anybody take an oath. But if you were to take an oath and say, I'm innocent of all charges, so help me God, that's the oath part, so help me God. It's a promissory oath. I'm innocent of all charges, so help me God. Well, now they need to bring forward their evidence to show that you aren't. Otherwise, you're free. Go look up purgatory oath. All right, that's another way to do it. Look at purgatory oath, look at decisory oath. Look at these words up in the dictionary to see what they are, and you'll get an idea of the way the system is being used. Like in the decisory oath, because the plaintiff doesn't have the evidence to make his case, he's deferred the oath to you. Now, if you don't have the evidence to defend yourself, then you're going to be quiet. But if you do and you take the oath, well, now the plaintiff is screwed because he doesn't have the evidence to make his case. That's why he hasn't taken an oath. So you tell the judge, I'm innocent of all charges, so help me God. Or, the plaintiff never lent me any money, so help me God. And if he balks, say it again. I say, are you refusing to take my oath, Judge? All right, then I appeal your decision to the bishop. I'm going to take your ass to the church court. In 1215, the Fourth Council of the Lateran affirmed the use of inquisitorial system. 1215, that was a time of the Magna Carta. The council also forbade clergy from conducting trial by ordeal or combat. As a result, in parts of continental Europe, ecclesiastic courts operating under the inquisitorial procedure became the dominant method which disputes were adjudicated. In France, the parliaments, the lay courts, employed the same proceedings. And a lay court is a court with lay judges, lay without religious training, and answerable to the civil society, the civil authority, rather than to any church. But they used the same system. In England, Henry II had established a secular court during the 1160s. That court would have been for the Jews, because about 1160, between 10 something whenever the Normans invaded England, and 1215, the kings of England, at the Jews' request, made the Jews in England the king's property. And because they were the king's property, they had the king's protection. And they were allowed to have their own courts. And as a Christian, if you had a complaint against a Jew, now that they were the king's property, you had to go to the king's officer and put in your complaint. That's what the secular courts were. While the ecclesiastic courts of England, like those of the continent, now you have to remember, at this time, all these countries in England or in Europe are all Christian nations. They have a king who's a Christian, they're following Christian law. Right? So all the courts were ecclesiastic Christian courts. While the ecclesiastic courts of England, like those of the continent, adopted the inquisitorial system, the secular common law courts continued to operate under the adversarial system. The adversarial principle that a person could not be tried until formally accused continued to apply for most criminal cases. In 1215, this principle became enshrined in Article 38 in the Magna Carta. No bailiff for the future shall, upon his own unsupported complaint, put anyone to his law without credible witnesses brought for this purpose. The first territory to wholly adopt the inquisitorial system was the Holy Roman Empire. The new German legal process introduced in 1498. The new German legal process, I should have looked it up, was introduced as part of the Reformation in 1498. The adoption of some criminalists in 1532 made the inquisitorial procedure empirical law. It was not until Napoleon introduced some other stuff of the French Code of Criminal Procedure that the classic procedures of Inquisition were ended in all German territories. A little history there. In the development of modern legal institutions which occupied the 19th century, for the most part, jurisdictions did not only codify their private law. Private law is really what civil law is. We'll see that in a bit. And criminal law, because private law is between man, right? It's a private matter, and criminal law is between you and the state. But the rules of civil procedure were reviewed and codified as well. Through the movement, the role inquisitorial system became enshrined in most European legal systems. However, there exist significant differences in operating methods and procedures between the 18th century, the ancient regime courts, and the 19th century. So they tweaked it. Tweak. Now we got the Freemasons involved. 1717, Freemasons come into play, and they decide we're going to turn everything into a republic. We're going to take God, we're going to get rid of Jesus Christ as the Son of God and say there's just a deity. Don't matter what book you use, whatever you believe, as long as you believe there's a supreme architect. That's what we call ours, right? That's what the Freemasons said. You're following God's law. It's a bunch of bullshit. They're devil worshippers. They're the ones running things now. That's why that stenographer on the day of the vote for this, our latest reprieve to open the government up again, said that the Constitution had been written by Freemasons. Because it had been. And Freemasons are devil worshippers, right? They're going to take an oath that says, I'm not going to tell my buddy's secrets. Well, they just condemn themselves in the eyes of God. They put a curse on themselves, and now Satan is allowed to enter them and overtake them. If they stay in it long enough, they're gonna, because of their occult activity, allow Satan to possess them, whether they know it or not. It would be too much of a generalization to state that the civil law is purely inquisitorial and common law adversarial, right? That isn't the way it works. Indeed, the ancient Roman custom of arbitration has now been adapted in many common law jurisdictions to a more inquisitorial form. The main feature of now this is in France, right, that has the inquisitorial system. In criminal justice in France and other countries functioning along the same lines in the function of examining or investigating judge, the examining judge conducts investigations into serious crimes or complex inquiries. As members of the judiciary, not in the executive, independent and outside the province of the executive branch, and therefore separate from the office of the public prosecution, which is supervised by the Minister of Justice. So that's the way it should work. If you're going to use this system, these judges are part of the judiciary, and they're not under the public prosecutor. In America, that isn't how they're using it. The prosecutor is acting as the judge, and the prosecutor is part of the executive, and they're under the Department of Justice, which is all executive. There's none of the shit's in the judicial branch. in America. But the vast majority of these cases are therefore investigated directly by law enforcement agencies under the supervision of the public prosecutor. That's how it works here. Right? So even in France, they only had 33,000 cases where they used a judge, and the rest of them, the investigation was by law enforcement supervised by a public prosecutor as an executive function. So the judge questions witnesses, interrogates suspects, orders searches for other investigators. The role is not to prosecute the accused, but to gather facts, and as such, their duty is to look for any and all evidence incriminating or exculpatory. So what we should be able to do, right, if this was truly a judge in an inquisitorial system, is say, Judge, there is no sworn complaint against me. Go look at the evidence. And they would go look at it and say, well, by God, you're right. Let's go find out what's going on. Hey, prosecution, where's the sworn complaint? We don't seem to have one. Well, we're going to have to throw the case out. That's how it should work. But here in America, the clerk of the court's going to tell you, well, nobody puts in a sworn complaint. Both the prosecution and the defense may request a judge to act and appeal a judge's decision before an appellate court. In the past, the examining judge could order committal of the accused, this power being subject to appeal. However, this is no longer the case, and other judges have to approve committal orders. Again, this is the way it's supposed to work. In America, right, they can put you in jail before they send you to trial. It's because they're doing it all through the under administrative law, which allows them to make their own rules, adjudicate their own cases, execute their own orders from the rules. If the examining judge decides there is a valid case against a suspect, the accused is sent to an adversarial trial by jury. Again, this is the way it's supposed to work. The examining judge does not sit on the trial, has nothing to do with it. The case is tried before a court in a manner like that of an adversarial court. The prosecution seeks the conviction of the accused criminals. The defense attempts to rebut the prosecution's claims. The judge and jury draw their conclusions from the evidence presented at a trial. So, now in America, right, your right to a jury trial is preserved. If it's for a value greater than $20, your right to a jury trial is preserved. If you're not in a jury trial, you're not in a trial. You're just in a hearing. You're not in a judicial trial. You may be in some kind of executive, looks like a trial, smells like a trial, but really it ain't a trial. Examining judges are used for serious crimes, murder, rape, and criminal and crimes involving complexity such as embezzlement, misuse, and corruption. All right, that's what the examining judges are used for. As a result, judicial investigation, defendants being able to have judicial proceedings dismissed on procedural grounds, such as there's no sworn complaint. During the examining phase, cases where the evidence is weak tend not to reach the trial stage. That's the way it should be. Conversely, the guilty plea and plea bargaining were until recently unknown to French law, and now it only applies to crimes for which the maximum sentence of 1 year imprisonment. Therefore, most cases go to trial, including cases where the prosecution is almost sure to gain a conviction. Whereas in countries such as the United States, these would be settled by plea bargain. And it's the plea bargaining that you do with because that's the rules that were set up in the administrative system by the prosecutor, where they they're the ones who are going to determine if you're guilty or not guilty. One of the last things they're going to ask you before you step up to see the judge or the guy behind the bench is, are you pleading guilty or not guilty? That's your trial. The judge is the appeal. Or the guy in the black robe is your appeal. Administrative justice. In administrative courts, such as the Council of State, litigation proceedings are markedly more inquisitorial. Most of the procedure is conducted in writing. The plaintiff writes to the court which ask explanations from the administration or public service concern. When answered, the court may then ask further details from the plaintiff. Right? So the plaintiff writes to the court. That's how this court works in administrative justice. When the case is sufficiently complete, the lawsuit opens in court. However, the parties are not even required to attend the court appearance. That's why there's nobody there for the plaintiff. And this is like in a foreclosure. Right? All this shit's done ex parte. It's done between the plaintiff or the plaintiff's attorney and some unknown court that we're not even being part of. And it's all done ahead of time until it's sufficiently complete, and then they bring you to court. This method reflects the fact that administrative lawsuits are, for the most part, matters of formal procedure and technicalities, having nothing to do with substantive law. It has nothing to do with are they trying to steal your property or not. It's are you following a procedure and the technicalities. If you don't, doesn't matter if you're innocent, you're going to be found guilty. Inquisitorial tribunals within the United States. Certain administrative proceedings within some common law jurisdictions in the United States may be similar to their civil law counterparts, but are conducted on a more inquisitorial model. For instance, tribunals dealing with minor traffic violations at the New York City Traffic Violations Bureau are held before an adjudicator who also functions as the prosecutor. In other words, it's being held before the prosecutor. They question witnesses before rendering judgment and setting the fines. The prosecutor is your judge. What's an adjudicator? Is someone who presides, judges, or arbitrates during a formal dispute. The term adjudicator essentially means a judge without invoking the legal term. In other words, it ain't the judge, because a judge would be a legal term of the judicial branch. Formal, relating to matters of form. Right? It's a formal dispute. The argument's over the form. Held before an adjudicator who also functions as a prosecutor. Think about it. When you go to traffic court and talk to the prosecutor, that's your adjudicator. That's who questions you before rendering a judgment and setting the fines. They're going to find you guilty, and now they're going to send you. And if they guilty and you agree you're guilty, okay, boom, well, there you go. That's all done. There's no evidence given to the judge. Nothing given to the judge. If you claim not guilty, well, now you're going to go to a guy sitting there who's going to be he's basically the appeals court. These type of tribunals or boards function as an expedient form of justice where the state agents conduct an initial investigation, and the adjudicator's job is to confirm these preliminary findings through a simplified form of procedure that grants some basic amount of due process and fundamental justice, in which the accused party has an opportunity to place his or her objections on the record. All right, so the state agents is the police. They do an initial investigation and they give it to the adjudicator, who's actually the prosecutor, who's going to confirm these preliminary findings through a simplified form of procedure that grants some basic amount of due process and fundamental rights, but not everything. And you get to put your objections on the record. Administrative law is a body of law that governs activities of administrative agencies or government. Government agencies' action can include rule-making, adjudication, or the enforcement of a regulatory agenda. Here you go. Government agencies' actions can include legislative, judicial, and executive functions, all within a government agency. That's how they circumvent the separation of powers. They get to make their own rules, they get to judge their own rules, they get to enforce their own rules. What are you going to do? Administrative law is considered a branch of public law. As a body of law, administrative law deals with decision making of administrative units of government, for example, tribunals, boards, or commissions. Now, this is one of the reasons that we went to this apostolic signatura, because when you go look at, which is the highest church court, they have jurisdiction over, it's the supreme administrative court of the church. And you can take administrative matters to them. But there may be something we can do without going to them. And that's, I'll get there eventually. Civil law countries often have specialized courts, administrative courts that review these decisions. The plurality of administrative decisions contested in administrative courts are related to taxation. Okay, so they have specialized courts, administrative courts, that review the decisions of these administrative officers running their own little system. Administrative law expanded greatly during the 20th century as legislative bodies worldwide created more government agencies to regulate the increasing complex social, economic, and political spheres of interaction. So this administrative court is like the appeals court to this tribunal, which is part of a government agency that has the power to make the rules, to judge the rules, and enforce the rules. So if you're dealing with an agency that can make the rules, judge the rules, enforce the rules, you've got to find the correct administrative court to go to appeal their decision. And we'll see where that is. Administrative law and common law countries, generally speaking, most countries that follow the principles of common law have developed procedures for judicial review that limit the reviewability of decisions made by administrative law bodies. Well, go figure. They've developed procedures so that you can have limited judicial review. Often these procedures are coupled with legislation or other common law doctrines that establish a standard for proper rulemaking. Administrative law may also apply to review of decisions of so-called semi-public bodies such as non-profit corporations. So a non-profit corporation is in the administration and they're a semi-public body, and apparently they get to make their own rules too. Disciplinary boards and other decision-making bodies that affect the legal rights of members of a particular group or entity. While administrative decision-making bodies are often controlled by larger governmental units, their decisions could be reviewed by a court of general jurisdiction, like the civil or the circuit court, under some principle of judicial review based upon due process or fundamental justice. Could be. However, what they said here is have developed procedures for judicial review that limit the reviewability of decisions made by the administrative law bodies. Judicial review of administrative decisions is different from an administrative appeal. Alright, so here's where we got to ponder this for a minute. When sitting in review of a decision, the court will only look at the method in which the decision was arrived at. Whereas in an administrative appeal, the correctness of the decision itself will be examined, usually by a higher body in the agency. Now, the original definition of an appeal was you were going to appeal a willfully false judgment or perjury by witnesses. That's what an appeal was. So a judicial review, this would be under the court, then under the circuit court, of an administrative decision is different from an administrative appeal. When sitting in review of a decision, so they've already decided to put you in jail, the court will only look at the method in which the decision was arrived at. What does that mean? So they're going to look at the procedure. They're going to look to see if they follow a procedure. That's all they're going to do, looks like. And that's where you say, well, where's the sworn complaint? That's what judicial review. Whereas an administrative appeal, the correctness of the decision itself can be examined, usually by a higher body in the agency. Okay, so if you went with an administrative appeal, you could say something such as, by what authority did they bring the charge? prove to me that that guy's a policeman who gave me this ticket. I don't believe he's a policeman. I believe he's a private contractor. That's pointed out by Rod Class. They got the courts to agree, to tell him all the cops are private contractors. Well, he's a private contractor. He isn't working for the state. He can't give me a frickin' ticket. He's just a Kmart employee. By what authority do they bring this charge? Let me see their credentials. This difference is vital in appreciating administrative law in common law countries. The scope of judicial review may be limited to certain questions of fairness or whether the administrative action is ultra vires. Ultra vires meaning beyond the powers. By what authority, right? Do they have the power to do what they did? And slightly less literally, beyond the powers, although is standard legal transition, beyond power. If an act requires legal authority and it is done with such authority, it is characterized in law as intra-virus, within the powers. If it is done without such authority, so by what authority, is ultra-virus. Acts that are intra-virus may equivocally be termed valid, those that are ultra-virus invalid. So let's think about this here. If the traffic situation, prosecutor's acting as the judge, guilty, not guilty, they want to know, you're already giving it to them. Where do they send you next? They send you before a guy sitting there behind a desk. Is that an administrative appeal or is that a judicial review? I think that's the administrative appeal. And we want to have a judicial review because the judicial review is going to determine if they're acting beyond the powers that they have. So if the cop is a private contractor, then by what authority did he bring this charge? And did he put in a sworn complaint? In terms of ultra-vires actions, in the broad sense, reviewing court may set aside an administrative decision if it is unreasonable or arbitrary or arbitrary power, basically, or capricious under U.S. Administrative Procedures Act and New York state law. Okay, so who is this judicial review? Right, that's the civil authority. That's one of the people we're looking for. The power to review administrative decisions are usually established by statute, which were originally developed from royal prerogative writ, such as mandamus and certiorari. Okay, some of this stuff we don't really need to go through. You can read it later. Administrative law in civil law countries. Don't really need that. United States administrative law encompasses a number of statutes and cases which define the extent and powers, responsibilities held by administrative agencies of the United States government. Right? So that's what case law is all about, is to determine how much power these administrative agencies can have. The executive, legislative, and judicial branches cannot always directly perform their constitutional responsibilities. Specialized powers are therefore delegated to an agency, board, or commission. These administrative government bodies oversee and monitor activities in complex areas such as commercial aviation, medical device manufacturing, security markets, yada, yada, yada. The federal agencies have the power to adjudicate, legislate, and enforce laws within their specific area of delegated power. Right? Again, there's no separation of power. And they all answer to the executive. So they all answer to the president. So really the president has just grabbed all the powers to adjudicate, legislate, and enforce through all these administrative agencies they set up. Okay. So they got rulemaking. And you got state, inquisitorial system. We already pretty much covered this, but Rather, the presiding judge is primarily responsible for supervising the gathering of evidence necessary to resolve the case. That's in the inquisitorial system. Presiding judge is primarily responsible for supervising the gathering of the evidence necessary to resolve the case. The inquisitorial system seeks the truth by questioning those familiar with the events in dispute. The adversarial system places a premium on individual rights of the accused, whereas the inquisitorial system places rights of the accused secondary to the search for the truth. The inquisitorial system was introduced by requiring witnesses and defendants to take an inquisitorial oath administered by the judge, who then questions the witnesses. Well, there ain't nobody taking an oath. In civil trials under either system of justice, the defendant or respondent may be required to testify. In most inquisitorial systems, a criminal defendant does not have the power, does not have to answer questions about the crime itself, right? Doesn't need to incriminate himself, but may be required to answer all other questions at trial. Many of these other questions concern the defendant's history and would be considered irrelevant and inadmissible in an adversarial system. Right? They're going to ask you, even if they have you take the witness stand, they're going to ask you a bunch of shit that has nothing to do with anything, because they're going to say you don't have to incriminate yourself. And what you should do is say, I'm innocent of all charges, so help me God. You've just taken an oath. Now they got to produce their complaint. The criminal defendant in an inquisitorial system is the first to testify. The defendant is allowed to see the government's case before testifying. Right? You don't get to see that stuff. So we're not using a true inquisitorial system. We're using a system that uses the inquisitorial format that was made as part of the rule making for an administrative agency that's going to make the rules, judge the rules, enforce the rules. All right. In the U.S., inquisitorial systems may be used for summary hearings in the case of misdemeanors. So you're going to have the inquisitorial system, and a summary hearing is where you go to, you're going to plead guilty or not guilty. All right. So, hopefully that wasn't too confusing. Now we're going to look at what a lawyer, our administrative system of criminal justice that Gerald E. Lynch wrote, and that's actually, where is that thing here? There's a PDF that I found from Fordham Law Review, Our Administrative System of Criminal Justice, 1998, Gerald E. Lynch. And I've tried to cut some down to make it not quite so long. But lawyers in common law tradition like to emphasize the difference between the Anglo-American adversarial system of criminal justice and the continental or civilian inquisitorial system. The conventional wisdom among U.S. lawyers tends to glorify the American system, which is claimed to be more protective of liberty, more democratic, and less dominant by agents of the government established than the civil law tradition, thanks to the role of the lay jury, the formal equality between the representatives of the government and the defendant, and the neutral independence of the judiciary. That's if you're in a trial with a frickin' jury. But, how often are you in a trial with a jury? The purpose of this essay is twofold. First, I want to describe more realistically the theory and practice of plea bargaining in the United States, so as to defend and explain the purpose it serves. And second, I want to situate the practice which reflects the adversarial inquisitorial distinction. Okay? In fact, I will claim the American system, as it is actually operated in most cases, looks much more like what common lawyers would describe as a non-adversarial administrative system of justice than like the adversarial model they idealize. So we keep talking about this common law system, but it never actually gets used. And it starts with plea bargaining. In an adversarial system, the typical criminal procedure course in American law school describes alphabet in greater detail, a process that students essentially recognize from the high school civics course. Grand jury accused defendants of crimes that are carefully defined in the penal code after appropriate motion practiced to sharpen the issues for trial, the prosecutor's attempt to convict the defendant by persuading jurors, yada yada yada. If the jury finds guilt, the judge imposes a sentence by assessing the aggravating and mitigating circumstances to the extent that such course step from the particulars of step back from the particulars of constitutional, statutory, and judge-made rules governing the details of the system, and attempt to characterize the system as a whole in comparative terms, the American Anglo-procedural system is typically described as adversarial, forgetting what the Constitution says, statutory law says, and what the judge say, in opposition to supposedly inquisitorial system. That is, litigation is controlled by parties, the state and criminal defendant, who stand equal before a neutral court. That's what the adversarial is supposed to be. A jury of lay citizens, rather than professionally trained judicial officers, determines whether guilt has been proven. So again, unless you're sitting there in front of a jury, you're not in an adversarial trial. You're in some kind of inquisitorial system. Right? If the Constitution says your right to a jury is preserved if the value of the dispute is worth more than $20. Well, if you're in a foreclosure and they're saying that you owe the house $150,000, where's the frickin' jury? Where's the jury if it's worth more than $20? They're not there. So either it's not worth more than $20 or you're not in a common law court. You're in an administrative court. You're not in the judicial branch. You're in the administrative branch. And we're going to find the place you take these administrative complaints to have them looked at. Of course, the model procedure text, note that the adversarial model, so elaborately defined, defended and attacked, is not, in fact, a perfect description of what actually occurs in our criminal courts. Jeepers, go figure. It is acknowledged that the grand jury is largely a tool of the prosecutor, that guilty pleas often result of carefully negotiated plea bargains dispose of far more cases than are tried, that those bargains, sometimes in combination with sentencing guidelines, often dictate the sentence imposed by the defendant. Right? Somebody's made up some rules. It is recognized almost as an aside that cases disposed of without trial. There is no jury at all. No witnesses appear for cross-examination. Such factual information as the judge receives beyond the defendant's own acknowledgement of guilt, there may be none, will likely be presented in written summary rather than oral form. Normally in common law courts, everything is done orally. In Inquisitorial, it's done by paper. All right, so in the most cases, there's no jury, no witnesses. Whatever factual information the judge receives, and there may not be any, will likely be presented in written form rather than oral form. And most importantly, the only real assessment by the Institute of Justice of whether the accused is actually guilty of an offense charged is made by police and prosecutor, not by the absent jury or by the judge, who simply accepts the voluntary and intelligent decision of the defendant to waive trial. Right? So you got to tell them, I mean, if you want to go through this shit in the courtroom, you're not waiving your trial. These inconvenient facts, however, they're inconvenient, inconvenient facts are typically seen as distortions. Don't pay any attention to it. Don't look that way. The elegant model of procedure that applies in principle, but that sadly is often departed from in practice. Right? We don't always follow what we say we're going to do. That's what it says we're supposed to do, but we're not going to follow that. Plea bargaining and prosecutorial discretion may control the fates of most defendants, but these practices are rarely seen as a system in their own right. Plea bargaining and prosecutorial discretion, which is them acting as the judge, may control the fates of most defendants, but these practices are rarely seen as a system in their own right. They're not written down anywhere. You can't find where it says they can do this. There is no rule that says they can do this. It's just by custom. One seldom sees an acknowledgement in the debates over the superiority or inferiority of adversarial systems that for most defendants the primary adjudication they receive is in fact an administrative decision by a state functionary, the prosecutor, who acts essentially in the inquisitorial mode, which means he's acting as the judge. While some special rules may apply to criminal cases, the essential structure of criminal cases is nothing more than another ordinary lawsuit. The state, like a private party in a tort or contract action. So first of all, what they're saying is there really isn't any difference between a criminal case and a civil case. And there really isn't, because either way you're being charged for breaking a law. That's what a tort is. A tort is you breaking a law that harms another private person. And a contract action, all there can be is there fraud in your contract? You following the contract or not? If not, well, it's fraud. It's just one entity that may come before the court to present the claim for relief, and the defendant is nothing more or less than a party from whom the relief is sought. Just as in a civil case, if the plaintiff elects to withdraw his complaint, or if the defendant acknowledges his liability and agrees to the relief, there is no longer a dispute for the court to resolve. As in civil case, the parties may settle their disagreement by jointly agreeing to some compromise. If they do, the court will not much inquire into whether that it is the right result under the law, for their compromise once again has the effect of leaving no dispute for the court to arbitrate. Right? So they're going to use civil procedures basically in a criminal matter, coerce you into agreeing with them and leaving the court nothing to arbitrate. Plea bargaining, in this sense, grows directly out of the adversarial notion that the parties stand as equal autonomous disputes before the court, and the court is not an independent engine in the state administration of justice, but rather an arbitrator for such disputes as parties choosing to bring before it. So if you agree ahead of time to be guilty, well, then you never brought the complaint before the court. But if plea bargaining grows out of an adversarial ideology, its widespread practice has resulted in the development of a system of justice that actually looks, to most defendants, far more like what American lawyers would call an inquisitorial system than like the idealized model of adversarial system described in the textbooks. What happens if we think of American criminal justice as one in which an administrative agency, called the Department of Justice, administratively decides, subject to judicial review, who is worthy of criminal punishment? It is commonly understood that most cases are disposed of without trial. The exact percentage is hard to compute, but 80 to 90% of felony indictments fail to produce a trial. Formally, of course, any determination of culpability occurs in court, even in class cases disposed of without a trial. Formally, of course, any determination occurs in court, even in cases disposed of without trial. The court enters a judgment based on the defendant's judicial admission of guilt in a plea of guilty. Sometimes this plea follows a fairly extensive course of judicial proceedings, indictment, discovery, motion practice, even expedientiary hearings by a court, but in many cases it occurs at the very outset of the formal process. In a substantial number of cases, the judicial process consists of the simultaneous filing of a criminal charge by the prosecutor, often by means of the prosecutor's information rather than an indictment, right? Whatever he got from the police department, not an indictment from the grand jury, with the defendant waiving the submission of the evidence, with the defendant waiving the submission of evidence and the charge to the grand jury. So somehow we waived our right to have whatever they have sent to the grand jury, and they're just working off the information from the from the police department and the admission of guilt by the defendant. in charging document may be quite skeletal. The defendant's account of his guilty actions brief and the judicial inquiry concerning more with whether the defendant is of sound mind and understands the consequences of what he is doing, rather than with the accuracy of the facts to which he is attesting. Critics complain that it is entirely inadequate. How can a civilized country send people to prison for many years based on a perfunctory judicial analysis of the facts and law? Mustn't we do more than this to avoid mistaken convictions? If we insist on seeing formal judicial proceedings as a locus of adjudication, then the critics are undoubtedly correct. Right? If you really think you should go before a judge and a jury as your form of adjudication, then you're correct. All this crap that happened here, this charging with this limited document, yada yada yada, off of an information not from a grand jury, right, is inadequate. In most guilty plea proceedings, the judge does not have enough information to make an intelligent determination of whether the defendant's guilt is even likely, let alone certain. A system of actually adjudicated criminal cases on the basis would be indefensible. In fact, however, society is not relying on the judiciary to decide guilt in these cases. The substantive evaluation of the evidence and assessment of the defendant's responsibility is not made in a court at all, but within the executive branch in the office of the prosecutor. Again, this is all done in the executive branch with the prosecutor. It has nothing to do with the judge. The judiciary is not even involved. The brief formal procedure in court obscures what can be invisible but elaborate and lengthy process of adjudication of the defendant's guilt. This process is rarely governed by formal legal standards other than the basic definition of offenses, and the procedures by which it operates are not usually written down anywhere. It's all done by custom. There is no rule that says they can do this. They just do it. The prosecutor, the judge in her own case. Criticism of American criminal justice often stops right here, having demonstrated that the judiciary plays a severely limited role in determining guilt, and that the prosecutor is the controlling figure in a typical criminal case. The liberal critics rest, confident that the system is now laid bare before self-evidently hypocritical and unfair. The prosecutor is one party to what is supposed to be an adversarial proceeding, and to show that he is really the judge in his own case is ipso facto to discredit the system. The prosecutor is going to be the judge in this proceeding. If further evidence of unfairness is necessary, the critics need only point to the disparity of power and resources between the state and the typical criminal defendant, and conclude that the system is actually an operation as distinct from the theoretical model offers little to protect the innocent. It is true that guilty pleas are often entered by frightened, powerless defendant on advice of overworked and underqualified appointed defense attorneys or lawyers, under the threat of lengthy prison sentences if convicted at trial, facing pre-trial detention that may itself, even if the defendant is ultimately acquitted, exceed the sentence being offered as part of the plea bargain. In cases that may have received as little attention from the equally overworked and underqualified prosecutors, but this reflects the unfortunate maldistribution of resources in the United States more than the intrinsic difference between bargain and administered justice and the trial system. Right? In other words, hey, we're going to screw you. There's really not much you can do about it. Right? You're going to be coerced into agreeing to something because we're going to tell you, look, you're going to go to prison for this long if it goes to trial, and we're going to put you in jail ahead of time under pretrial detention, which is actually, it's going to take 6 months for your trial to show up. You know, if you go now and just take the guilty plea, you only go to jail for 3 months. Take your pick, 6 or 3. And then after the 6, may find out you need to go to jail for 3 years. What are you going to do? Right? That's called coercion. The claim that a non-adversarial process conducted by an official who happens to be called a prosecutor is intrinsically unfair begs the question. The claim that a non-adversarial process, so there's no adversary, conducted by an official who happens to be called a prosecutor, but is really sitting there as the judge, that's unfair begs the question. Such a process may not be preferable to the traditional common law system. It may not even be acceptably fair, no doubt. But it is hardly self-evident that a system in which the responsible government official is assigned to investigate allegations of crime by investigating means strictly limited to protect the rights of suspects and then to make decisions based on the results of the investigation after hearing evidence and arguments presented by the suspects is beyond the pale of civilization. In other words, hey, trust him. He works for the government. We're here to help. We wouldn't screw you. Indeed, that is not so very different from the model of criminal procedure used in most of the world, as it appears both defenders and critics of adversarial regime. They're all doing the same thing, except for 30,000 cases in France where they actually used the Inquisitorial judge the way they're supposed to. The rest went through the prosecution, just the same as here in America. The process of administrative justice, because our governing ideology does not admit that prosecutors adjudicate guilt, judge guilt, and set punishments, the procedures by which they do so are neither formally regulated nor invariably followed. In other words, we're not going to even let you know they exist. Most commonly, in all likelihood, the prosecutor simply accepts the results of the police investigation, and any process of independent adjudication occurs at the instigation of the defense counsel. If you don't ask for it to be adjudicated, they're not going to do it to be an independent adjudication. The prosecutor is just going to render his own judgment. It's up to you to take it to the next level. Just as the trial process only comes into play when the defendant contests the prosecutor's judgment, so the administrative process depends on the defendant's decision to question within the prosecutorial bureaucracy the conclusions of the police or investigative agency. Notably, the rules of criminal procedure do not give a suspect or defendant the right to be heard or to present evidence to the prosecutor. Right? If you go look in the procedures, you don't get to give evidence to the prosecutor or even be heard by the prosecutor. So you need to go. So the administrative process depends on the defendant's decision to question within the prosecutorial bureaucracy the conclusions of the police or investigative agency, such as where's the sworn complaint? By what authority did you bring this charge? Are you actually a police officer? Because you don't get to go talk to the prosecutor himself. It's not allowed by the criminal procedures. The rule conceives of the prosecutor as an autonomous party of an adversarial proceeding, who has no obligation to listen to his adversary's arguments. The prosecutor has the unilateral authority to decide what to investigate to the extent that certain steps required the assent of other bodies, such as the grand jury, issues subpoenas, judicial officers, authorized warrants. The prosecutor presentation to those bodies are ex parte, the epitome of non-adversarial process. Ex parte means there's no adversary. It's one of the definitions. And the prosecutors go into these people ex parte like there's no adversary. Yet they're supposed to be your adversary in a adversarial type of law system of common law. The ultimate decision whether to bring a charge, moreover, or whether to accept a guilty plea, or some other disposition in satisfaction of the government's claims is left to the prosecution's essentially unreviewable choice. Can't review their decision. Defense counsels contact the prosecutor during the preliminary stage of an investigation range from informal contacts designed to find out the nature of the allegations to elaborate formal presentations arguing the prosecution is not appropriate, that the evidence is insufficient, Right, so those are things that you might bring up if you were sitting in front of the judge. Remember, the prosecutor is the judge. Guilty, not guilty. You've made your choice. Now it's going to go to your appeal within the executive branch, and that's that judge sitting there. And you might tell him, well, there is no evidence. They didn't put in a sworn complaint. I don't know that that's the best thing to do. As the investigation reaches its conclusion, defense counsel will often make extensive formal arguments to the prosecution about the appropriate ultimate disposition of the case. Such presentations typically proffer of factual information and evidentiary materials, as well as arguments concerning the merits of the case and factors relevant to the prosecution discretion. These presentations are not limited to the prosecutor in charge of the matter. If the line prosecutor rejects the defense's contentions, counsel may seek appellate review by the prosecutor's supervisors. Well, the prosecutor works for the state within the executive branch. So somewhere in the executive branch is the prosecutor's supervisors. At ascending levels of prosecutor bureaucracy, from the chief or criminal division chief to the United States Attorney or District Attorney, yada, yada, yada. It is easy to see in these proceedings an informal but nevertheless quite distinct system of administrative adjudication. Although both defense lawyers and prosecutor bureaucracy may operate within one eye of eventual litigation that may result at the end of the internal process, surely an influence not unknown in administrative agencies formerly conceived as adjudicatory, it would be a mistake to analogize these decisions. Some of this stuff is hard to understand. The prosecutors involved in these decisions typically see themselves as public officials making decisions that are substantial part adjudicatory. That is, prosecutors are not seeking to simply maximize the amount of jail time that can be extracted from the adversary, regardless of her guilt or innocence. Rather, they undertake to determine, in response to the defendant's arguments, whether the evidence truly demonstrates guilt. If so, what sentence is appropriate? Prosecutors are not seeking to simply maximize the amount of jail time that can be extracted from their adversaries, regardless of guilt or innocence. I don't know about that. Moreover, the process used to make the decision involves an opportunity for the affected parties to argue and even present evidence that they are not guilty, or at least cannot be demonstrated to be guilty beyond a reasonable doubt. That such procedure exists and that undertake of a quasi-judicial functions does not mean that they are necessarily fair. As noted above, there is no set form for these proceedings. Some characteristic features noted, however. Internal prosecutorial process is never formally adversarial. In some circumstances, one could roughly envision the prosecutor as adjudicating between competing positions being asserted by police or investigative agencies on the one hand and the defense on the other. So the prosecutor is sitting there adjudicating between the police and you. Unlike a judge or jury, the prosecutor remains free to speak ex parte with either defense lawyer or the police, and frequently does so. Moreover, the extended nature of these ex parte contacts are hardly symmetrical. They're always talking to the police. In my experience, police federal agents are usually present at least the most formal stages of the defense presentations and remain present after the defendant's representatives are dismissed. However suspicious law enforcement agents may sometimes be of whether prosecutors fully share their priorities and values, and however much the common culture of the bar may at times unite the prosecutors and defense lawyers against their respective lay clients, in final analysis, the prosecutor is part of the law enforcement complex that shares policy goals with the police. Law enforcement agencies and prosecutors are thus, in critical respects, on the same team. So you got a guy adjudicating between the police and you who's on the side of the police. Go figure. and their discussion, unlike those between prosecutor and defense lawyers, are affirmatively concerned with accomplishing shared goals like getting your money. If the prosecuting functions as an adjudicator, she clearly does not function as a neutral umpire, and the process over which she presides does not fit an adversarial due process model. In other words, none of this shit follows the law. Even more importantly, the usual burdens of production of persuasion tend to be reversed in these proceedings. In a normal adversarial hearing, the government, as a party seeking to change the status quo, would be required to serve notice of charges and to present its cases on imposing sanctions before the defendant would be required to respond. That's how it should work. The internal prosecutorial process is different. The initiative in seeking a hearing is on the defense. Only if counsel seeks a meeting with the defense will the defense position be heard before formal judicial proceedings are invoked. It's what we need to do. The initiative in seeking a hearing is on you. The burden is typically on defense counsel to rebut a case that may have been disclosed to her only in the sketchiest form. The precise nature of the charge has not usually been specified, and the evidence on which they will base is not often disclosed. There's all the things that you can go, if you find the right place, to have a hearing because of these things, right? It's not been disclosed to you. The precise nature of the charge has not been specified, and the evidence has not been disclosed. In effect, the defense must shoot in the dark at possible moving target whose identity is uncertain. The decision maker, moreover, is under no obligation to give reasons for the rejection of the defendant's argument. These features significantly limit the fairness and efficiency of the internal process. No shit. Because the procedures are not codified, not written down anywhere, however, but negotiated case by case in context with custom, in particular instances, the process can extend greater protection to the defendant. The prosecutor then is making determinations of guilt or innocence, right? Because one of the things they're going to ask you, are you guilty or not guilty? Because American lawyers have large investment in the myth of adversarial system, it's a myth, it is hard for us to even see this administrative system as punishment, let alone approve of it. We cannot easily see the prosecutor as an administrator because we are not going to look. Because in the adversarial proceedings that may follow the administrative decision, the prosecutor will play a role of the adversarial party. Because the prosecutor represents one side in anticipated adversarial proceeding, to acknowledge her role as a de facto adjudicator would be to make her the judge in her own case. Thinking of the prosecutor as an administrative official may also affect our understanding of prosecutorial discretion. They don't think of the prosecutor as an administrative official. They, in their head, these other lawyers want to think of them as being part of the judicial branch, just like we do. They're not. They're part of the administration. They're part of the administrative branch. Few would dispute that there are too many crimes in two different senses. Certainly, there's too many harmful criminal acts being committed. Most legal academics, however, would probably also agree that there are too many criminal statutes on the books and that those statutes are frequently too broad and too vague. So long as the de facto administration process operates within the shell of a due process model, the defendants retain the power to opt out of that process and submit themselves instead to a formal judicial procedure that is bound strictly by due process rules. That is a much stronger protection for the innocent than the deferential reasonableness review of prosecutorial decisions. Operating within a system that defines them a formal adjudicative role, prosecutors remain largely free of bureaucratic requirements and retain considerable flexibility to implement changing views of public interest. Operating within a system that denies them formal adjudicative role, so they're denied it, however they're using it, it's just not written down. While American, now it's not that they should be doing it, and that's why we need to go complain, but because we're not complaining to the correct body, right, they get away with this stuff. Why all American jurisdictions provide a defendant with at least some discovery of evidence against him after formal charges is brought, and many provide very full disclosure of the evidence. There is no provision for discovery in connection with prosecutorial decisions to charge, because the decision to charge is not seen as an adjudicatory act, but simply as a unilateral decision by the government to institute a proceeding. Right? They fit eggs within eggs within eggs. In a proper inquisitorial system, defendants have access to dossiers compiled by authorities. Right? These are the proper ones. In our system, defendants have to make critical decisions, because we're in an improper inquisitorial system, whether to accept the prosecutor's determination of guilt before any significant discovery of the prosecutor's evidence is required. Prosecutors can thus find defendants guilty without giving the defendant an opportunity to make use of exculpatory evidence or to find weakness in the state evidence. That's why we got to get away from the prosecutor and go somewhere else to put in our complaint. The right to be heard in connection with charging decisions is even more fundamental. In the best prosecutorial agencies, defense attorneys have customer access to supervisory prosecutors, but this process is nowhere required by law. Once we conclude that prosecutors in their discretionary charging and plea bargaining decisions are acting largely as administrative quasi-judicial decision makers, this recognition must necessarily be strengthened. Right? We have to say that's what they're doing. So what is it we're going to do about it? Well, this is what I found. This is what I found just the other day. Administrative law, the basics, a practical introduction to administrative law in Michigan. This is from the Michigan Bar. One of the most common areas of dispute between agencies and the public is whether agencies' internal guidelines or policies must be proclamated as a rule to be enforceable. Right? So first of all, we want to know if they did their stuff as a rule. MAPA narrowly defines guidelines to mean only agency statements and policies that, while binding on the agency, do not bind to other persons. So the guidelines don't, only the rules do. Practitioners of administrative law must always be wary of secret rules that, while never subjected to public scrutiny, establish standards of procedures that the agency routinely enforces against the public. Some agencies have entire regulatory programs based on standards and procedures that have never been proclamated as rules. These situations present the difficult situation of dealing with an agency when the guidelines for the agency relies on and regulating your client is not readily accessible to you or the public. However, the situation also presents an avenue for legal challenge to the agency position and better chance of achieving negotiated resolution to the dispute at hand. Agency adjudication. In addition to legislative or rulemaking authority, among most important powers granted to the agency is adjudicative. Again, they're going to legislate, they're going to judge, and they're going to execute. The courts have facilitated this policy through the doctrine of primary jurisdiction and exhaustion. The doctrine of primary jurisdiction posits that even in cases where the circuit court has concurrent jurisdiction over the matter before the administrative agency, it will defer to the agency to adjudicate the matter. Well, I don't want to do that. I want it to go to the court. I don't want it to be adjudicated by an administrative agency. Exhaustion is jurisdictional barrier restraining a court from adjudicating a claim before the aggrieved party has pursued all remedies available before the pertinent agency. Right? You've not exhausted your administrative remedies, what they tell you. As a practical matter, then, a person aggrieved by the agency, licensing decision, enforcement action, and other determination must use administrative proceedings to remedy the situation if such proceedings are available. And they are. In such cases, there is no right for judicial review until a completion of the agency proceeding. And this is what we're going to do. Finally, we're going to get to the meat of it. Where are you? That was 3. Where's 4? Yep, don't need that. Here's what we got. First of all, Michigan organizational chart. View, rotate. There's the governor, the executive. All the offices within the government fall under the executive. Here's one called civil rights. Right? Administrative review. Civil Rights Division. Let's see what the Civil Rights Commission says. Department of Civil Rights, Civil Rights Commission. See if we get all this to fit on here. By authority conferred on the Civil Rights Commission, Section 29, Article 5 of the State Constitution. Yada, 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 yada. Civil rights within the Commission jurisdiction. Rule 1. Right? So this is a rule of the Civil Rights Commission. The civil rights within the jurisdiction of the Commission shall be those guaranteed by law and the Constitution, including but not limited to the areas of equal protection of the laws, employment, education, housing, public accommodation. The jurisdiction of the Commission shall not be limited to the processing of complaints. And it gives some definitions. But let's go down here and look at complaints. Any person claiming to be aggrieved by unlawful discrimination made by himself or herself or his or her counsel or other agent make, sign, file with department a complaint. Assistance in drafting and filing complaints shall be made available without charge to claimants at all department offices. We're supposed to go to the Civil Rights Commission and put in a complaint because we are being denied equal protection of the law because they're not using the law, they're using custom against the law. Because the law says if there's a criminal complaint against me, there has to, if I'm being charged with a crime, there has to be a sworn criminal complaint. Or does it say that? Well, it says that right here. Actually, it'd be easier if I go this way. So here's an example. Michigan Vehicle Citation. Using this act, citation means complaint or notice upon which police officer shall record an occurrence involving one or more vehicle violations by the person cited. Good stuff. For the purpose of this act, the complaint signed by the police officer shall be treated as made under oath if the violation alleged in the complaint is either civil infraction or a misdemeanor or ordinance violation, not greater than 90 days. And if the complaint contains the following statement immediately above the date and signature of the officer. If you're in Michigan and you got a ticket and they say it's a citation, it's going to be considered to have been made under oath if it says directly above where the officer signed and dated, I declare under the penalties of perjury that the statements above are true to the best of my information, knowledge, and belief. But it doesn't say that. It's not a citation. It's not a sworn complaint. You're not guilty of anything. Nobody's put in a sworn complaint. Now, in the criminal code, It says, a complaint is a written accusation that a named, described person has committed a specified criminal offense. The complaint must include substance of the accusation against the accused and the name of the statutory citation of the offense. The complaint must be signed and sworn to before a judicial officer or clerk. For there to be a complaint, it needs to be sworn to before a judicial officer or clerk, unless it's a citation, in which case the citation needs to say immediately above the date and signature of the officer, I declare under penalties of perjury that the statements above are true to the best of my information, knowledge, and belief. So, if it doesn't say those things, then you're not being given equal protection under the law. The other thing, by what authority did this policeman bring the charge? I haven't seen his oath of office. I don't know that he is even a police officer. He could be a contractor. As they told Ron Class, right, that all the cops are basically contractors. But this is the administrative procedure, right? This Civil Rights Commission is in the administrative branch, and it's where you go to if you've been denied equal protection under the law. Anything to do with housing, so you could go here also for housing, because as part of your foreclosure, what these attorneys really are debt collectors, and there's a certain set of laws within the state laws that they're supposed to follow for debt collection, and one of them is a certain affidavit that lists the debt, specifies specifically what it is, and none of that shit's in your case. So you would take your complaint to the Civil Rights Commission, and according to this, they got people there that assistance in drafting and filing complaints shall be available without charge to claimants of all department offices. Any commissioner, the director, or agent authorized by the commissioner or director may initiate, make, sign, and file a complaint. The complaint shall be in writing, the original being signed and verified before a notary public or other person duly authorized to administer oaths, take acknowledgement. The complaint shall include the following, right? So you could do it yourself. The full name and address of the claimant, the name and address of the respondent, the alleged discrimination, statement of any other proceeding, civil or criminal. The complaint shall be filed at one of its offices. Yada, 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 right? So I haven't really studied this, but it's pretty simple. We're trying to figure out where to put our complaint into. And if you want to say that you've exhausted your administrative remedies, well, here is a remedy that you have to have used. You have to go to the Civil Rights Commission and put in a complaint. And you can put it in against the prosecutor in your traffic case to say that there's no sworn complaint against me. That would be for any criminal matter. Any criminal matter requires a sworn complaint. Now, the other thing is, the only difference between criminal and civil is this. Civil is between two people. Criminal is between you and the state. Either way, you're being charged with a crime. If you're being charged with a crime, there has to be a complaint. If there's a complaint, complaints have to be sworn under oath, or it's not a complaint. So we can get into that stuff a little bit deeper on another video, because I'm about tired of talking about this. But my point is, this whole video was to show that we're not ever really in a trial because there's no jury. So you're in under some administrative process. In an administrative process, the way it's set up, you need to exhaust your administrative rights because of this crap they did. Right here, where the courts have facilitated this policy through doctrines of primary jurisdiction and exhaustion. And in the exhaustion, it's a jurisdictional barrier restraining a court from adjudicating a claim before the aggrieved party has pursued all remedies available before the pertinent agency. Right? You haven't exhausted your administrative remedies yet, so the court's not going to hear it. I'm not saying it's fair. I'm saying it's the way they put the system together so they can say they're not breaking the law and still take your shit. So here's a possibility of using a system that's already in place, and maybe this is how we get it to the civil authority. I don't know. However, I'll leave you with this, right? This is something to try that we haven't tried yet. What we did is we skipped this step, not even really knowing it existed, and we just went to the church court because the church has concurrent jurisdiction for things under oath, things to do with perjury, any temporal matter that has an element of sin involved. The church has jurisdiction. The Pope claims jurisdiction over all baptized people. They have a court called the Apostolic Signatura. It looked like to us that the way you approach this court was through the chancellor at the local diocese. We've tried it twice. In one case, the petition is on its way to Rome now to go to the Apostolic Signatura. In the other case, the chancellor said he's not getting involved because this is a private matter. Well, we're going to work on him, and we're going to see what happens with the other one. But here's another option. Go to the Civil Rights Commission or whatever it is you have that gives you equal protection of the laws. And now it looks like in Illinois, Roe did a little looking. It's the Human Rights Division. So, gonna have to do a little research, and we'll see what comes up next. But that's where we are today. And again, if you can, please, because I can really use it. It's the end of the month in 4 days, and I can't pay my rent. PayPal account is ashleyritluski@gmail.com, and my snail mail is Robert Ritluski, 10955, 14 Mile Road, Rockford, Michigan, 49341. God bless. Take care. We'll talk again soon. See ya.